Morning, Your Honor.
Good morning.
Morning.
How you doing? No green, no white.
Yeah.
Have a seat, sir. And that don't even work, bro. I ain't gonna even let you make that walk. They ain't fixed it since the pandemic.
Okay, first up, I have Ms. Fanning. Good morning, Ms. Fanning.
Good
You're on
morning.
fire.
Yes, I am, Your Honor.
Case number 2305-860501. For the state of Michigan versus Brandon Myers. Defendant is charged in count one, assault with intent to do rape of a harm less than murder by strangulation. Count two, domestic violence. Defendant has a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
Good morning, Your Honor. The police court attorney, Andrea Fanning, P 42853, appearing on behalf of my client, Mr. Brandon Byers. Your Honor, I would waive his appearance here today for purposes of this CCC. I would indicate I have been in contact with him. I spoke or texted with him this morning as it relates to this matter.
Defendants, what's your pleasure?
Your Honor, we'd like to continue this matter to exam, please.
Court will continue to plead not guilty and set this matter for preliminary examination. How is September 6th at 10:45?
Oh, that's gonna be tight. Can I do it on Friday, the 8th at all?
And how's September 8th at 11:30?
That's great. Thank you, Your Honor.
We continue.
I thank you. You have a wonderful day, you and your staff. Thank you. Bye-bye.
Mr. Noakes, good morning.
Good morning, Your Honor.
How can I help you this morning?
I'm here on behalf of Ms. Luana Glenn. If she's not on Zoom already, I'd waive her appearance with your permission.
Bringing her out the waiting room now.
Following case number 2305-858701. People of the state of Michigan versus Luana Glenn. Defendant is charged in count one, weapon expired, discharge being let building. Count two, weapon expired, possession by felon. Count three, assault with a dangerous weapon. Count 4, 5, and 6, weapons of the firearm. Count 7, domestic violence. Defendant has a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
Good morning. May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit, on behalf of Ms. Luana Glenn. And Your Honor, if she isn't present, I would ask to waive her appearance.
Ms. Glenn, tell us your name for the record.
Luana Taisha Glenn.
What's your pleasure, Mr. Noakes?
Your Honor, we're requesting a preliminary examination.
Can you do September 6th at 10:45?
I will.
September 6th at 10:45.
Thank you, Your Honor. And Ms. Glenn, I'll call you later today to speak with you about this.
Okay, thank you.
You're welcome. Bye-bye.
Oh,
Good morning, Your Honor.
good morning, sir. You're here on David Burke.
Yes, Your Honor. Thank you.
Oh, case number 2305-84-5301, State of Michigan versus David Burke. Defendant charged in count 1, operating while intoxicated, causing death. Defendant has a habitual offender, third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Sarah Bonomo on behalf of the people, Pete 4189.
And good morning, Your Honor. Jonathan Cohen from Neighborhood Defender Service, P86151, appearing by Zoom with Mr. David Burke, who is by Zoom. And Mr. Burke, if you can unmute your mic, put your camera on and state your name, please. Mr. Burke is about 10 feet away from me in my office. So there he is. All right.
David Burke.
Tell us your name for the record, sir.
David Burke.
I could barely hear you, but I did hear you. Okay, what's your pleasure, Mr. Cohen?
Thank you, Your Honor. After review of the discovery and discussions with my client, Mr. Burke would like to waive his right to a preliminary examination and have this matter bound over to the circuit court.
All right. Mr. Burke, please raise your right hand. Raise your right hand, Mr. Burke. There you go. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
See your mouth move. Say it louder for me, sir.
Yes, Your Honor.
Okay. You can put your hand down, thank you. You understand you have a statutory right to have a preliminary examination. By waiving and saying that means you won't have one, you'll be bound over to Wayne County Third Circuit Court as you stand charged. You understand that?
Yes. Yes, Your Honor.
You understand the nature and the purpose of a preliminary examination?
Yes.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, and there's probable cause to believe you committed it?
Yes, Your Honor.
Is anyone forcing you to waive your right?
Yes.
Who's forcing you to waive your right? Who's forcing you to waive your right, sir?
No.
No one is forcing you to waive your right?
No.
Are you waiving your right freely and voluntarily?
Yes, Your Honor.
Does anyone promise you anything?
Good morning.
Oh, Mr. Aaron, I'm in the middle of a hearing. Has anyone promised you anything?
No, no, Your Honor. I'm hard of hearing.
That's okay. Any objection from the people?
No, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court finds the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date, and time would be September 15th, 2023 at 9:00 a.m. Trial will be continued.
Thank you, Your Honor. Have a good day,
Thank you.
everyone.
Thank you, you too. Mr. Brown,
Good morning, Your Honor.
how can I help you, sir?
I'm here on Clifford Smith.
Okay.
Call me case number 2305-854601, people of the state of Michigan versus Clifford Smith. Defendant is charged in count 1, assault with a dangerous weapon. Count 2, domestic violence. Defendant has a habitual gift of 30 days notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Brian Brown, P80560, appearing on behalf of Mr. Clifford Smith, who is present on Zoom. Mr. Smith, please state your name for the record. He's muted.
Clifford Smith.
All right, what's your pleasure, Mr. Brown?
Judge, we would like to set this for an in-person preliminary examination. Can I have a breakout room with my client also afterwards?
All right, can you do September 6th at 11:15?
September the 6th, 11:15. Yeah, I can do that.
All right, September 6th at 11:15, bond will be continued.
All right, thank you. Can I have a breakout room with Mr. Smith?
Hang on. Go ahead and join the breakout room.
Thank you.
Mr. Polk, good morning.
Good morning, Judge.
So I tried to wait on you as long as I could yesterday.
Yeah, and then when I did come, I was coming over there for an exam in person, and I should have called earlier. By the time I called, they said you were gone, so it's fine.
Okay, ready on Coleman.
Call me case number 2305-732801, people of the state of Michigan versus Cortez Cole. Defendant is charged in count 1, homicide, murder, first degree premeditated.
Appearances for the record, please.
Yes, good morning, Judge. APA Larry King for the people, P78774.
Your Honor, may it please this honorable court, Larry Polk on behalf of Cortez Coleman. I believe Mr. Coleman is, no, he's in the Wayne County Jail. I don't know if he's on screen.
Are you waiving his presence or you want to wait on him?
I will ask the court to allow me to waive his presence if he is not visible at Wayne County.
And I have no objection, Judge.
Well, we're waiting to defend his presence. What's your pleasure?
Well, Judge, today was the date and time as it relates to a competency. I am in receipt of a competency report where the forensic analyst found my client to be competent. And so with that, I'm at the point willing to stipulate to that report and set this matter for preliminary exam.
Will you so stipulate as well?
Your Honor, I have received and reviewed the report, and I stipulate as well to its admission and to a finding of competency.
All right, the court makes a finding that the defendant is competent to stand trial. What's your pleasure, Mr. Polk?
We need to set a preliminary exam date, Judge.
Okay, House September 12th at 10 o'clock.
Bear with me, Judge. Your Honor,
go ahead.
That is a conflict time for me. I'm not going to be able to do the 12th. I could do the 14th that week if it works for the court of Mr. Polk.
You can't do any time during the 12th?
Your Honor, I'm scheduled to be in a CSC trial on the 11th, 12th, and 13th.
How many witnesses do you have on this case?
1 second, Judge. Let me check that. Mr. Coleman for the preliminary exam. Sorry, my system's being a bit slow.
I believe when we discussed it, you said 3 to 4.
I think that's right, but I want to double check, and it's just literally just a click away if it would work. I have 4 witnesses under subpoena. 2 of them may be redundant, so I may only need to call 3.
Okay. How is September 14th at 11:30?
That does work for the people if it works for defense.
It does not, Judge. Much as I hate to say it, it doesn't.
1:30?
No. I have a 2-person exam that I just set in Judge Sabri's at 1:30 on the 14th.
And 11:30?
On the 14th?
Yes.
No, sir. I'm in federal court at 10:45, so I don't think I'll be finished by 11:30. If the court can just wait 1 second, I might have a different date for that other exam. No, I don't, Judge. It is the 14th.
September 19th.
Okay. That's great for me.
To be in
That's
trial that day.
Let's go back. So Judge, you said 11:30 on the 14th?
Yes.
Um, 10. We can set it for then. Oh man, I got this federal court at 10:45. It gives me 45 minutes there. I think I might be able to do that.
People would be agreeable to 11:30 on the 14th.
All right. September 14th at 11:30-ish.
Thank you, Judge.
Thank you so much, Judge. I appreciate it. Have a great day.
Thank you.
Yep, thanks, Judge. Enjoy your weekend.
You too. Enjoy your holiday.
Yep, thank you.
Andrea Fanning.
Yes, Your Honor. I returned because there was a request that I had that I failed to make known to the court.
What's that?
Currently my client, there's a no contact provision as it relates to where my client was residing. I'm just trying to see if I can get permission for a third party to go to the residence to retrieve his personal effects.
That has to be something we're gonna have to work out with the prosecutor.
Ms. Drain, would you be amenable to allowing a third party, and you can give me a date, time specific for a third party to go to the residence to retrieve personal effects?
I will contact the complainant today and see if I can work that out, and I will let you know.
I appreciate that. Thank you. And I'll follow up with you. Thank you so much. Thank you, Your Honor.
Thank you.
Bye-bye. Thank you.
Irwin? Ms. Irwin? Is she leaving? Ms. Irwin going once? Ms. Irwin going twice? Mr. Greenwood?
Time for Greenwood. Okay, yeah, I have Byford.
Oh, Byford, okay.
Yes, sir.
Calling case number 2305-860901, people of the state of Michigan versus David Piper. Defendant is charged in count 1, domestic violence, third offense.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And greetings, Your Honor. Emmett Greenwood on behalf of defendant P56556. Your Honor, my client is currently on the phone. He hasn't been able to work the Zoom, so I'm respectfully asking that that his presence be waived. His presence be waived for this hearing.
For the waive the defendant's presence, what's your pleasure?
Your Honor, we're respectfully asking that this matter be set for an examination. I believe it's a one-person exam.
Yes, that's correct.
Court will continue the plea of not guilty and set this matter for preliminary examination. On September 6th at 9:45.
Let me check right quick. That's good for defense, Your Honor.
Okay, September 6th at 9:45. Will be continued.
Oh, Ms. Drain, can you please send me the discovery?
Yes, I'll send it to you.
Okay, thank you.
Okay.
Thank you, Judge. You have a good holiday and a good weekend.
Thank you, you as well.
Right,
Mr.
thank you.
Jersey, good morning. Mr. Jersey, are you there?
Good morning, Your Honor.
Good morning, sir. How can I help you?
Yes, I'm here, Your Honor. I'm here on Robert Defendahl.
Okay.
Is he here on Zoom?
No, I don't think so. We call the case.
Calling case number 2106-103501, people of the state of Michigan versus Robert Defendahl. Defendant is charged in count 1, domestic violence, third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And Robert Jersey, P33195 for Robert Defendahl.
What's your pleasure, Mr. Jersey?
We waive his presence and that's just for exam.
Court will continue to waive the defendant's presence, continue the plea of not guilty, and set this matter for preliminary examination. How is September 8th at 11:45?
September 8th at 11:45 is fine, Your Honor.
All right. Will be continued. Mr. Brown, are you ready on Smith now?
Yes, Your Honor. We just wanted to address Mr. Smith's bond conditions. We already did set it for a preliminary examination, but if we can address the bond.
15. Okay, back on the record on People versus Clifford Smith, case number 2305854601. Okay, what's going on, Mr. Brown?
Yes, Your Honor. If we could, Mr. Smith has a GPS tether and he's on house arrest when he does release, whenever Wayne County gets around to giving him a tether. However, we're asking for just maybe a few hours out the day for Mr. Smith to take care of his personal responsibilities. He has been displaced from his previous location where he was at Riverfront Apartments, and he's going to be at a house on the west side where he doesn't have any type of supplies there. He doesn't have, so he's going to have to go shopping. He's he's working, and he has children, that he's responsible for. So we're just asking for, him having the ability to, leave the house, for, somewhat of the day so he can take care of his responsibilities. He does understand that the GPS, tether, forbids him to go anywhere near the complaining witness, which is downtown Riverfront, which is far away from where he's going to be at. And he understands if he violates that, he's going to have a tether violation and he will be subject to incarceration.
Mr. Turner?
Your Honor, at this point, I am not objecting to the defendant having some hours with the tether.
Mr. Brown, you said he's working?
Yes, he does say, yes, he does work, yes. And I'm not, Mr. Smith, he has a lot of different odd jobs. That's what he told me. One of them is, it's on YouTube, but I know that's, doesn't, it doesn't require him to travel to do that job. But most, I think Mr. Smith wants to say something. Mr. Smith, you want to unmute?
Yes, well, they do pay me for basically traveling out and interacting. I just need a couple hours to try to get my life back and run back some money.
Doing what? Doing what, sir?
Pardon me, I couldn't hear you.
What do you do, Mr. Smith, what do you need to do in order to get your life back in order?
Well, basically it is my life. So that's just me interacting. I have a multimedia group, so I host events, sponsor events, product placement, artist development, music, the studio.
Sound kind of shaky.
And Your Honor, most importantly, he would like to go, be able to go shopping, run errands. He definitely needs to go shop. He doesn't have any type of supplies at this house. He wasn't previously staying there, so the house is vacant. And I'm not sure what type of appliances it has there. He was leading me to believe that all his appliances were at Riverfront, as far as his refrigerator, his stove, and whatnot. So he needs to at least get the bare essentials at his new location. So he's not asking free roam, just maybe a couple hours, few hours a day, where he can go and take care of some business and run some errands.
All right, because the alternative is we have very available accommodations in the Wayne County Jail. He doesn't have to worry about going to get anything to eat, or we'll give him 3 squares.
Oh yeah, with all due respect. With all due respect, Your Honor, yeah, he understands that, and he's grateful for the bond, and he also understands that that particular option that you just mentioned will be his only option if he were to disregard the conditions of his no contact order.
I can't help but ask, but it looks like the client's been injured in some kind of way. Are you okay, sir?
Your Honor, and without saying too much without the case, this was how he looked. I have the body cam. This is how he looked, and not going too much into the case. We believe the complaining witness made the story up, and she's the aggressor, and she's the one who assaulted my client. So this happened at the day of the incident, and I'm glad you noticed that, Your Honor. So when we come to exam, that's going to be very pertinent.
That's going to be an interesting exam. So a young lady did all that to him, allegedly?
Allegedly, yes, Your Honor, with a weapon, with a bottle.
All right, I'm gonna give him 2 hours out per day. What 2 hours do you want, sir? You don't want the 2 hours?
Yeah, no, I definitely want the 2 hours, sir. I was just trying to see which would be the best 2 hours for me. Maybe 2 to 4.
That's fine. Send me a stipulated order or an order to that effect, Mr. Brown.
I'll do that, Your Honor. Thank you.
Okay, thank you. Have a good day.
You too. Thank you.
Ms. Irwin.
Yes. Hi,
Good
Judge.
morning.
Good morning. I have Raheem Bender.
Calling case number 2305-859501, people of the state of Michigan versus Raheem Bender. Defendant charged in count 1, assault with a dangerous weapon, count 2, domestic violence. The defendant has a habitual offender.
Appearances for the record, please.
Morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Sally Irwin on behalf of Raheem Bender, 32405. We're seeking an exam date.
Are you waiving Mr. Bender's presence?
I will, Judge. Yes, I have spoken to him.
Court will waive the defendant's presence, continue to plead not guilty and set this matter for preliminary examination. How is September 8th at 12 o'clock?
Judge, that would be very difficult for me.
Okay,
My
how about-
11th is open.
How about September 6th at 11:30?
The 14th I can do.
You're going backwards. I asked about the 6th.
The 6th, no, Judge, I can't do it. I'm in trial.
When is your trial?
I start on that date and it'll probably bleed over. I could probably do it on, I start another trial on the 7th, Your Honor.
So you can't do the 8th?
8th. At what time, Your Honor?
What time is good for you?
I can fit that in, Judge. Go ahead.
What time is good for you?
11.
So I can do 12.
Okay, I'll do it, Judge.
Okay, September 8th at 12 o'clock, final be continued.
Thank you.
Thank you. Good day.
Have a good weekend.
Thanks, you as well. Ms. Hamilton.
Yes,
Wayne County Jail. Oh, Ms. Hamilton, what can I do for you?
I have Amelia Hicks who should be in the Wayne County Jail.
Did you want to wait on her or waive her presence?
I can waive her presence.
Okay, we're ready on this. Hey, man. Thanks, you too. Sir, in the Wayne County Jail, what's your name? Unmute yourself and tell me your name.
Robert Deffendorf, sir.
Okay, sir, we've already, Mr. Deffendorf, we did your case already. Your next court date is September 8th at 11:45. That's in person for a preliminary examination, 36th District Court.
September 8th at 11:45, sir?
Yes, sir.
Yes, sir.
We're all set. Thank you. Yeah, we're ready.
Calling case number 2305-858101, people of the state of Michigan versus Amelia Hicks. Defendants charged in count 1, assault aggravated, count 2, weapons, firearm, brandishing.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Miss Amelia Hicks. She is incarcerated in the Wayne County Jail, Your Honor, but I would request to waive her presence.
For the waive the defendant's presence, what's your question?
Your Honor, we'd like to set a preliminary exam date. And I'd also like to request digital discovery and specifically if the prosecution has any evidence regarding the PPO in this matter.
And how is September 6th at 11:30?
That works for me, Your Honor.
September 6th at 11:30, bond will be continued.
Ms. Hamilton, I already requested the digital discovery. I don't have any, and I will work on getting that, the PPO for you.
Okay, thank you.
Okay, thank you.
Excuse me, Judge King.
Yes, sir.
So the last one I have for you is Mr. I think it's pronounced Lanez, Brian Lanez,
Okay,
but I got him on a computer with Judge Jefferson right now as well.
okay, that's fine. His attorney hasn't arrived yet anyway.
No problem, sir. I'll just stand by on mute.
Okay, thank you. Oh, I see Detective Vanessa Burke.
Good morning, sir.
Good morning, ma'am. How can I help?
I am here on Michael Gregory is scheduled for Zoom this morning for an assault.
Michael Gregory?
Yes. Case number. The case number is gonna, oh gosh, I didn't write it down. My apologies. It should be popping up in 1 second. The case number is gonna be.
I don't see that on my.
Okay, I have a subpoena for 8:45 on September 1st, case number 230-585-0601.
What's the charge?
It was for an assault.
A simple assault?
It's on here on the subpoena, it says, it just says assault harm. That case got dismissed yesterday.
Okay, I'm told that that case was dismissed yesterday.
Oh, wow. Okay. Yeah, I just got the notice. Well, I got the subpoena in my email, so dismissed on yesterday's date. I appreciate you, sir.
Yes, ma'am. Thank you. Have a good day.
Thank you. You too. Bye-bye. Have a good weekend.
October. That's true. 22. Right.
Mr. Washington.
Good morning, Your Honor.
Good morning, sir. How can I help you?
I have a PCC on Shannon Jackson.
Okay. 31 seconds.
In case number 2205-827301, State of Michigan versus Shannon Jackson. Defendant is charged in count 1, assault with dangerous weapon, count 2, domestic violence. Defendant has a habitual offender for defense notice and a condition of a felony with the motor vehicle for advisory.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Shannon Jackson.
What's your pleasure, Mr. Washington?
I'm requesting a preliminary examination.
And how is September 6th at 11:45?
That date appears to be good.
Next, September 6th at 11:45, bond will be continued.
Thank you very much, Your Honor.
Thank
Have a
you.
good weekend and have a good holiday.
Thank you as well.
Attorney Grant is on Zoom. Oh, it's with Judge Jefferson. Oh, that's the one the attorney, the deputy was telling you, Mr. Lane's in another courtroom.
Good morning, Mr. Miller.
Good morning, Your Honor. Mr. Lanes and I just got off the record with Judge Jefferson. I don't know why they put him there first.
Okay. Mr. Drain, is this yours? Oh. Mr. Drain, are you on Lanez?
No, no, Judge, I am not.
You know who the APA is on that?
I will find out who that is.
Okay. Who's the APA on the other case, Mr. Miller?
Your Honor, the other is a courtroom one. It's a destruction of turf. This is a CSC.
Okay.
The system lists Elizabeth Moore, Your Honor.
Okay.
Yes, I do believe that this is Ms. Moore's case, and I just sent her a text. I'm just waiting for her response.
Okay, thank you.
I just texted her as well, Your Honor.
Good morning, Mr. Waiting on the attorney. Waiting on the prosecutor, rather.
I'll just call it. Too quiet here for me. Judge, I want this, I don't see an attorney, you have to call.
Yes.
Judge, I'm going to be standing in for Ms. Moore.
Okay. We're ready.
Calling case number 2305846901. People of the state of Michigan versus Brianne Lynette. Defendant is charged in count 1, criminal sexual conduct, 4-3, count 2, assault or assault and battery.
The record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249, standing in for the attorney of record, Elizabeth Moore.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Mr. Lands.
All right, and tell me your name for the record, sir.
My name is Brian Natalie Lainez Lands.
Okay, what's your pleasure, counsel?
Your Honor, we'd like to set this for an examination. It appears I have the discovery from the people, so we just need a date.
Okay, how is September 6th at 12 o'clock?
One moment, Your Honor. What was the time again, Your Honor? I apologize.
12 o'clock noon.
I can make that work, Your Honor.
Ms. Drain?
Your Honor, if I can have just a moment to make sure to see if that's a good date, just because it's so soon. I'm texting her right now.
The judge can hold him accountable. And so that's something else that I can bring up in court on Wednesday. Hey, the case started over a year ago now. There was no contest for an order. Within I started police on that.
She is asking for 9/8, Your Honor.
I can do September 8th at 12:30.
Your Honor, I just set the other examination with Mr. Lands for 11:30. Could we do 1 o'clock? I can do back-to-back exams, but I just figure I'm not going to start right at 11:30, Your Honor. But it should be a quick one.
Let's go to September 8th at 12:30 and we'll call it 12:30-ish.
Thank you, Your Honor.
Do we need an interpreter at all?
Not that I'm aware of. Mr. Lands, you speak English, correct?
Yeah, I graduated and New York. Yes, I do.
As long as you guys understand each other. Okay. September 8th at 12:30. File will be continued.
Thank you, Your Honor.
What did he say?
Your preliminary examination is going to be September 8th at 12:30 in 36th District Court.
Do I'm going home?
Your Honor, The court did not adjust his bond in the other hearing, but they did mark his file medical. He does have broken ribs. If this court would be willing to mark his file medical as well, just so he gets medical attention while he's in the jail.
I fell from a roof from 55 feet in the house in Bloomfield Hills.
Okay, I'll mark the comment.
And I had hit with a weapon in the back. Two guys robbed me with weapons and they hit me with the weapons. And I'm not feeling well. And I haven't taken my medication. They give it my medication when the nurse passed. I'm having attacks from the inside to my brain and to my arms from the rib. I had chronic headaches also, that's what the doctor said, and the hospital. I have the scripts that are 10 pills for $80. I'm the one who helped my mom and my sister. I have talked to her. I don't remember all the numbers.
I'm not sure why he's still talking to me, Mr. Miller.
I'm not either, Your Honor. Could the court disconnect the jail, please?
Sure thing.
First one is that PCC was on attorney.
I'm doing all right about yourself. Looking forward to the long weekend.
I reckon I'll probably find something to get done around the house.
Homicide.
Like you got more homicides today than you have a homicide day.
No, I didn't have any.
Temporary grade. You got one at 132. I got two.
It's good football this weekend. It's some good football this weekend. College football.
Oh, yeah. We'll take a look at Michigan State. I think they play today, right?
Good.
I think so.
They got a tough game too. Let's see.
Yes, sir. Can I help you? Connect your audio, sir.
Oh, I just want Colorado tomorrow.
Colorado?
Yeah, DM service.
Oh, yeah, yeah.
Yeah, like 20. Yeah, 68 new players from last year.
Wow.
68.
Wow.
Only kept 15 from the year before.
They got. They play.
TCU.
That's really good.
Yeah.
Michigan got a cupcake schedule.
Yeah.
Hey, no.
I was talking to, I can't think of his name right now. My dad works there. Son, his wife receiver from Michigan.
Yeah.
I was talking to him. I sent his wife was there yesterday. So I said, man, get some plans on.
Yeah, he said he's been working out with the ones and twos.
Well,
Kid is good.
that's what they've been missing though, receivers.
Yeah. They got a good quarterback too.
Got two great running backs.
Oh, yeah. And again, he's staying healthy. Good morning, Mr. Wallace.
Good morning, Judge. How are you?
Good. Are you here on Watkins?
No, I'm here on Childs. Anna Bickerstaff and Vassal Johnson should be signing in soon. I believe the people are asking for an adjournment for Tuesday's exam.
Ms. Bickerstaff is here.
Yes, Judge, that's correct. We are waiting on Mr. Johnson. We haven't received the medical examiner's report yet. Medical examiner's office.
So I'm curious, how do you sign the warrant and you don't have the medical examiner report?
Judge, I can say I didn't sign this warrant. They come to be signed. And this is how I received the file without a medical examiner's report.
So when is the report going to be complete?
Judge, I didn't get a definite estimate from the medical examiner's office, but if we could probably just have a week adjournment, I'm sure they can finalize the report by then.
Or we can have the medical examiner appear in person since they don't have the report.
I guess if the court's not willing to grant an adjournment, I can that avenue once I figure out who the medical examiner is.
Then maybe they'll start getting your reports. When you testify.
I got Central Michigan. Ain't no guarantee though.
So you got Central Michigan?
Yeah, Michigan State plays Central Michigan today.
I know. I thought you said you got.
Oh, no.
It's possible. They beat them before.
Yes, they have. My son, they play Auburn today. Me and Saturday. I'm gonna get killed. Auburn's pretty good, sure.
So they always have to.
School football team get $1.9 million for playing.
So what?
My son's school, playing Auburn, they get the football team gets $1.9 million to play.
Wow.
They play Penn State, they get 1.7 million. Sacrifice of getting beat up for some money.
Good morning, Ms. Woodside. Looking pretty judicial there.
Good morning. Oh, sorry, Bob. I'm multitasking as usual.
Oh, you didn't have to do that. I thought it was kind of fun.
Okay, stop. You teasing me, Judge. I am hopping on for Mr. Clifford Smith. The family just informed me he had court this morning. Have you done him already?
I have.
Okay. What happened with Mr. Smith?
Mr. Smith has an exam set for September 6th at 11:15.
Oh my goodness. Any chance of that moving to a different day?
Why?
Oh, you know what? Never mind. It looks like I'm gonna be in the building at different times of the day anyway. Okay, 11:15.
Okay, so you need discovery in this drain.
I do.
You retained on Smith?
I guess I will be. It's a family member of anyway, long story. Okay, I'll get with Miss Drain.
I'll send it to you. I'll send it to you today.
Oh, okay.
Okay, thank you. Have a wonderful weekend, everyone.
You too.
Going back to my other job now, Judge. Gotta go.
All right,
Stop it.
It's like I have a problem with the exam that's set for Tuesday. What's the defendant's name on this case, Ms. Bickerstaff?
Alexis Childs and Elijah Hill, 2 defendants.
Yes.
Calling case number 2305-8149. For the state of Michigan versus defendant number 1, Alexis Childs, and defendant number 2, Alicia Hill. Both defendants are charged in count 1, homicide, murder, first degree premeditated. Both defendants are charged in count 2 and 3, assault with intent to murder. Both defendants are charged in counts 4 and 5 and 6, weapons, felony, firearm. Defendant number 2 has a habitual fitness second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Anna Bickerstaff on behalf of the people, P82215.
Good morning, Your Honor. Ted Wallace, P80922. I represent Alexis Childs.
Good morning, Your Honor. May it please the Honorable Court, Vassal Johnson, P72130 on behalf of Mr. Elijah Hill.
All right. So is this the exam that I had adjourned because Mr. Johnson had just retained in on it? He had
Yes,
taken
Your
his
Honor.
kid because he's such a great parent.
Yes, Your Honor.
So Ms. Bickerstaff, my understanding is that you don't have the autopsy report.
That's correct, Judge. I did email the medical examiner's office last week requesting their documents, the medical examiner's report, body diagram, toxicology report, pictures, and anything else they had. I did receive back this week only the medical examiner pictures. I have not yet received any of the finalized reports.
Did you contact them to find out when that report would be forthcoming?
Judge, I did email them again requesting the ME report. I haven't gotten anything back. I haven't gotten back like an estimated time range, but I would just ask if we could have a week adjournment. If we don't have the medical exam report at that time, although I'm very hopeful we will, as the court had mentioned, I'll just subpoena the medical examiner to come in and testify before this court.
Perhaps you need to talk to someone instead of emailing, because that doesn't seem to be working. And if you didn't have the medical examiner's report at the first time this matter was scheduled for preliminary examination, you most certainly should have had it by this coming Tuesday. So I'm of the opinion that we either should have the report by Tuesday, or the medical examiner himself or herself come in and testify as to the results of their findings.
Okay.
That will probably light a fire rather than to get that report into.
Yes, Judge.
For some reason, they don't like to come testifying for me. They don't have to.
Yes, Judge.
Okay.
Thank you.
I'll see you folks Tuesday. Thank you.
Thank you, Your Honor.
Judge, my witness just arrived, if I can accept them. Speak with them, I appreciate it. Thank you.
59, 58, 57, 56, 55, 54.
Thank you very much.
You're the boss. I got nothing to do with that. Put the people where you want to put them.
You ready?
Yes, yeah, I apologize for that.
Sir, take your hat off. Calling case 2357867, for the state of Michigan versus Kyron Dontel Street. In discharge from count 1 homicide, murder, first degree premeditated. Count 2 assault with intent to murder. Count 3 assault with intent to murder. Count 4, 5, and 6 felony firearm. Appearances for the record.
Good morning, may it please this honorable court, APA Jonathan Pitts, appearing on behalf of the people, P8528.
And good morning, Gabby Silver, appearing on behalf of Kyron Cooper, who is present in court behind you.
This matter was held in part and continued to today's date. Are we ready to proceed?
Yes, Judge.
How many witnesses are we calling today?
I'm only calling one witness today. The witness that I was hoping to call, I don't believe is going to be there. So just one.
Okay. Preliminarily, you'd like to start with, or are we ready to call your witness?
I do not believe there's anything preliminary that I need to start with, so I'm ready to call my witness to the court. All right. People call Willie Campbell to the stand. And Judge, if I could be enabled on screen sharing, I appreciate it.
Sir, please give your name and the spelling of your name to the young lady seated there. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat in the witness box right next to me. For that door, and have a seat. Speaking to that directly into that microphone will be to your left. Make me ready.
Thank you. Good morning. Would you please say your name again for the record?
Willie Campbell.
And are you employed, Mr. Campbell?
Yes,
How so?
as a community developer.
What do you do in your capacity as a community developer?
Build affordable housing, provide food and clothes. for people who need it.
And if you could keep your voice up and speak in the microphone.
You can actually take that microphone, the whole base of it, set it in your lap so you can speak into it, okay? Just hold it up. There you go.
Do you have any relationship to a property located at 2265 West Grand Boulevard?
Yes, I do.
What is your relationship to that property?
I own that property and it serves as an office.
Is that address in the city of Detroit?
Yes,
Is that Wayne County, Michigan?
yes, it is.
Is that property equipped with any video recording equipment?
Yes, it is.
What type of equipment?
Ring cameras,
And what type of ring cameras is that?
on the front porch, I have a ring spotlight camera. And on the west side, I have 3 spotlight cameras that are solar powered. And in sort of like a wooded area to the rear, I have a ring stick-up camera. And I believe on the back of the house, I have a wise camera pointing north.
That front porch camera that you mentioned, what direction is that facing?
It's pointing south.
And in that camera's frame, are there any businesses that are visible?
Yes.
Which ones?
The apartment building directly across the street, gas station to the southeast, and the old Lee Plaza Hotel to the southwest, and Northwestern High School also to the southwest.
And if you know, what streets are visible in the camera's frame?
West Grand Boulevard and Linwood.
And to your knowledge, does that camera fairly accurately record the events outside of 2265 West Grand Boulevard?
Yes.
And are those recordings stored?
Yes, they're stored to the cloud.
And is there a timestamp included on those videos?
Yes.
To your knowledge, is that timestamp accurate?
Yes.
Do you recall providing footage from that camera to the Detroit Police Department back in 2021?
Yes, I do.
Was that footage altered in any way?
No.
And was that footage that you provided a fair and accurate copy of the footage reported by the camera?
Yes.
Now, prior to testifying, I showed you a file that I marked on my computer as People's Exhibit 10. Did you recognize that file?
Yes, I did.
What was it?
It was a video that I sent to Detective Boatman at his request.
And was that a fair and accurate copy of the video that you provided to Detective Boatman?
Yes, it was.
And to your knowledge, is that a fair and accurate recording generated by your camera?
Yes, it is.
At this time, I move to admit and publish People's Exhibit 10. No capture.
Admitted.
Mr. Campbell, if you could turn your attention to the screen. Now, I put People's Exhibit 10 on the screen at the 0-second mark. What's this road directly in front of the camera?
That's West Grand Boulevard.
And you mentioned Linwood Street previously. Where is that located?
That's to the left.
And what about those lights on the left-hand side of the screen? Do you know what those are?
That's from the gas station.
At this time, I'm going to publish People's Exhibit 10. In its entirety.
Yeah.
Sorry. Okay, I'm now going to publish People's Exhibit 10 in its entirety. Mr. Campbell, West Grand Boulevard, you mentioned previously, in front of that address. Could you describe that street?
It's West Grand Boulevard. It has a median in the middle where traffic going west is closest to my building, and traffic going east is on the other side of the median going east.
Thank you. I have no further questions.
Cross examine.
Yeah, I didn't see it, maybe it's. Was there a timestamp on that video? Can we look at that? I didn't see a timestamp. Judge King's face.
I didn't do it.
I've seen Judge King's face.
Let's see if this steps in.
That's okay, Judge. I saw it on Mr. Kitzel's. So you provided this to the Detroit Police Department in 2021, I think you said?
Yes.
Okay. How did you know to provide it? Did you look at it and provide it, or did they come by your house and ask for your business?
The detective came by my house and asked me.
Thank you. I have no other questions. Thank you.
Can you redirect?
No, Judge, not.
Thank you, sir. You may step down.
No further witnesses for the people.
Any witnesses for the defendant?
No witnesses today for the defense, Judge.
Speak.
At this time, Judge, people are going to move for a bind over on, let me make sure I'm getting the counts correct. Count 1, 2, 4, and 5. People are going to move to dismiss without prejudice. Count 3 and 6. I would also move to amend the information in count 2 because the identity of that victim has not been established to John Doe. And I'd like to approach and provide the paper exhibits to the point that previously. Okay.
So,
Well, Judge, if I made my argument.
oh, I'm sorry.
So, Judge, I anticipated a few issues here. First and foremost, I'm sure Ms. Silver is going to argue that the people have failed to adequately identify the defendant for purposes of preliminary exam. I would submit to the court that People's Exhibits 3B and 5B, which I've just provided, are more than sufficient to establish Mr. Cooper's identity for purposes of probable cause. The court will recall from the last hearing where Sergeant Ford testified to a string of green light videos that he recovered, leading from the gas station depicted in People's Exhibit 3B and 5B, all the way to the gas station where this shooting takes place. And I'd be happy to replay that video if the court would like to see it, but you can see that Mr. Cooper from these pictures gets into the driver's seat of this distinctive red vehicle, missing front right hubcap. And you can follow that vehicle all the way from this gas station down to the gas station where the shooting takes place. The second issue that I anticipate here is I would expect Ms. Silver is going to argue that I didn't establish who the shooter in this car was. I would submit to the court that it doesn't make a difference who the shooter actually was. Because either Mr. Cooper is guilty as a principal, as the one that pulled the trigger, or he's guilty as an aider and abetter to the individual that was in the passenger seat, which you can see in the video. It's not quite clear in People's Exhibit 3B. You can kind of see someone sitting in the car, but if you actually watch the entirety of the video, it's clear that there's a passenger. The court, and I'll play this now. We'll recall that Sergeant Ford testified to taking the green light video from the gas station in which the shooting took place, zooming it in, and blowing up the inside of this vehicle. If you watch that video, which I'm about to play, you can see that a passenger is not visible in the vehicle. Why is that? Because the passenger has leaned back and she is no longer in the frame. It's instead the defendant who's reaching across outside this vehicle and firing the 3 shots you hear in People's Exhibit 10 at the 2 victims that people have asked for bind over on. So I'm going to play People's Exhibit 9B now. And I've stopped it at the 15-second mark. You can see the defendant's white t-shirts. You can see him reaching across. You can see him bring his arm back into the car. The angle doesn't make sense for that to be the passenger there. It's the defendant, Mr. Cooper, who's in the driver's seat, reaching across the passenger side and firing the 3 shots in here. People's Exhibit 10 outside of the vehicle. With respect to the AWIM count, I am moving to amend that to a John Doe victim because the witness who did testify that the murder victim, the individual that lost their life, testified to his identity, Mr. Levert, did testify to the identity of the other person that was witnessed. He mentioned that he thought that person was Mr. Levert's brother, but he wasn't totally sure on who it was. Nonetheless, it was appropriate to find over as a John Doe because he's standing right next to Mr. Levert when the shots ring out, and when you can see on People's Exhibit 9A that Mr. Levert is shot. Mr. Cooper is firing 3 shots out of his car, and the court can certainly infer his intent from those 3 gunshots fired in their direction. And obviously hitting one, the fact that he didn't hit the other doesn't matter because inferring his intent. He's firing gunshots in the direction. The court should and can infer his intent to kill both those people. Nothing further. So.
Yes, Judge. Yes, I appreciate Mr. Hitz making my arguments for me. But it is absolutely clear to me that they have not established the necessary elements as it relates to Mr. Cooper being the individual that is doing a shooting on this date and time. We certainly did see a string of green light video of a car that Mr. Hitz says that Mr. Cooper is driving in. There's an allegation that Mr. Cooper gets into the driver's seat at some point during that night, but we don't have there's no evidence that it's Mr. Cooper still driving that vehicle later in the evening when these shots are fired allegedly from this vehicle. Mr. Hitz says, well, it's obvious to see that Mr. Cooper is wearing, it's the same white t-shirt, which is pretty common attire for young people these days, not only in Detroit, but throughout our communities. People wear white t-shirts. Young people, old people wear white t-shirts. There's no testimony to support that that is Mr. Cooper that is in that car at that point in time, yet alone driving the car, yet alone firing a shot. Mr. Cooper says the passenger is not visible because she leans back. There's no evidence to support that the passenger in that vehicle is a she. There's no evidence to tell us who all is in that vehicle at the time that the vehicle, that shots are being fired at this particular gas station. So, you know, it's our position that Mr. Hitz hasn't proven to a probable cause standard who the shooter is in this case. Mr. Hitz hasn't proven if this is a first-degree murder, a second-degree murder, a manslaughter. There's no testimony as it relates to that either. But I think the most significant argument is the absolute failure to identify Mr. Cooper in the vehicle at the time these shots were being fired, and Mr. Cooper is the shooter. And I get that it's only a probable cause standard, but this is about as little as I've seen in a long time as it relates to the identity of an individual who's doing a shooting. So for those reasons, Judge, it's our position that even with all the video we've seen, this last video that we've seen, it still doesn't establish what and who is carrying out this shooting at the gas station that morning. So for those reasons, we ask the court to dismiss the charges against Mr. Cooper at this time.
Yeah, something else, Mr. Woods?
If you want a brief response, just very quickly, Judge. I would just note that to say that Mr. Cooper was not the driver of this vehicle does not line up with video evidence that was presented here. Timestamps between the various green light locations showing this red vehicle with missing front passenger side lights, the front passenger side of that. Do not support that this vehicle could stop and the driver could swap out. That just defies common sense. Further, I neglected to mention during my argument that there at least is some cell phone record evidence to suggest that he was in the area at the time of the shooting, which further supports the people's position that this was indeed Mr. Cooper. That this was indeed Mr. Cooper.
Indeed, Mr. Cooper. Okay. So no question about it that the issue surrounding this case has to do with identification of the defendant as the person who fired these shots from the vehicle or was operating the vehicle that the shots were fired from. I think my issue is not so much that whoever it was that committed this murder is guilty of homicide, murder, first degree premeditated. Given the video evidence that the court has seen where this vehicle starts off pulling in front of the house, goes down the street, turns the corner, fires 3 shots, at least one taking effect to the complaining witness in this matter, and killing him. I don't think there's any question that we all were witness to a first degree murder premeditated. Not so convinced that you have an assault with attempted murder on a Joshua Allen or a John Doe, because not satisfied that there's been a showing that Joshua Allen or John Doe was in the line of fire, that whoever fired these shots from this vehicle didn't target who was shot, and specifically target who was shot. There was not sufficient evidence to bind over that John Doe or Joshua Allen was in the line of fire. For that reason, the court finds insufficient evidence to bind over on assault and attempted murder. Count 2, as well as count 3, which people have moved from this list. Going back to count 1, first degree murder premeditated. People have shown evidence that the defendant was the occupant of this red vehicle. The red vehicle is somewhat distinctive in that there's this missing hood cap. They've also shown that the defendant was in the area of the shooting by way of cell phone records and the like. Court had an opportunity to view the video. In fact, do you mind, Mr. Hicks, playing that video once more? The first one that shows the actual shooting. People are scattered, one, not the one that you showed today.
Yes, Judge.
Okay, while he's teaming that up. Mr. Miller.
Good morning, Your Honor.
Good afternoon. Almost afternoon. What can I do?
Almost afternoon. I was called for Mr. Watkins.
Oh, okay, you're helping me out. I appreciate it.
Yes, sir.
Calling case 2358604, people of the state of Michigan versus Michael Watkins. Defendant is charged in count 1 assault with intent to do great bodily harm, less than murder or by strangulation. Count 2 domestic violence. Appearances for the record.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Mr. Watkins.
All right, what's your pleasure, Mr. Miller?
Your Honor, I was just called, so if I could get some discovery and get an adjourned PCC date to maybe next Friday when I'm going to be before the court.
And that sounds reasonable. The court will adjourn the probable close conference to September 8th at 8:30. File will be continued.
Thank you, Your Honor. And Ms. Drain, you have my email. Can you just send me whatever you have, please?
I will.
Thank you.
Okay.
Have a
thank
great
you.
weekend, everybody. Go green.
Go what?
Go
Go blue.
go blue.
Go blue. All right, Mr. Cohen,
Good morning, Your Honor.
what can I do for you, sir?
So I'm standing in for Mr. Kenneth on an exam for a Jaquetta Hightower, who I believe is still in custody. And I was either going to stand in for a dismissal if the complainant was not present, or an adjournment if the people are ready. Mr. Kenneth's in a murder trial, I believe, at the moment.
Where is Ms. Hightower?
Oh, Ms. Hightower should be in custody, Your Honor. She was released on a personal with tether, but as of this morning was still showing in Division 1. So I think there's just a delay.
She's here. Yes, sir. Calling case 2358392, what state of Michigan versus Jaquetta Denise Hightower. Defendant is charged in count 1 assault with potentially great bodily harm, less than murder by strangulation. Count 2 domestic violence. Defendant has an additional criminal second offense notice. Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
And good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Ms. Jaquetta Hightower, who appears in custody in person. I'm standing in for the attorney of record, Mr. Jeff Kenneth.
Well, I understand that Ms. Hightower is in custody and she's been brought over, but I don't think we brought her up from downstairs yet. So we can wait for her presence for now.
That's fine, Your Honor.
See, Ms. Drain, are you ready to proceed?
Oh, Your Honor, I am not able to proceed at this time. The complainant is a Ms. Martha Hubbard. She was notified of today's date and time for the hearing. She is not present, and I cannot proceed without her testimony today.
Your Honor, we would move to dismiss on behalf of the defense.
So ordered. Court will dismiss this matter without objection. Thank you, sir. Appreciate it. Have a good day.
Thank you very much, Your Honor. You too. Have a great weekend, everyone.
Okay, we're back on the record on People versus Kyron Dontel Cooper. The video ready? We're missing this one. Oh. We got it, yeah. I'll try.
I have to say go blue now. My daughter defected from MSU to grad school, Michigan. They had a good program. I was go green, go white for 4 years.
I've always been partial to cream and crimson myself.
Oh.
Let's proceed, please.
This is People's Exhibit 9A from the 33-minute 1 second mark. And I've stopped it at the 33-minute 21 second mark.
So again, this video kind of supports the court's position that it appears that whoever was firing that shot from the vehicle intended to hit the young man that was in the all dark colors, because that person took off running. The other person that was standing with him stood off to the side and was in plain view and open. He wanted to shoot him or had intended to shoot him. He had every opportunity to do so at that point in time, but he didn't. So the court is of the belief that he hit his intended target. Court also notices from the video evidence that people presented in this exam that it appears as though the person I see in that vehicle was wearing a white shirt, a white t-shirt, and appears to be heavier in build or stature, such as the defendant is. So you tie the defendant to the area, tie the defendant to the car, and it looks like he's the one, that person in that white t-shirt that's firing the shot from the vehicle that shoots and kills Mr. Levert. I think we have enough circumstantial evidence, enough strong circumstantial evidence to bind the defendant over finding probable cause. That being said, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. That is counts 1 and 4. Court finding those charges were committed in the city of Detroit, the court finding probable cause to believe this has been committed will bind the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. His arraignment on the information date and time will be September 8th, 2023 at 9:00 a.m. Counts 2, 3, 5, and 6 will be dismissed for insufficient evidence. And it will be remanded to the custody of Wayne County Sheriff.
Thank you, Judge.
There you go.
Anybody else ready to take the seat for right now?
My next exam is at 11.
9:11:30.
I trail. I trail off my house. No, the microphone helps. I use my microphone. I was trying to keep my distance as a worry of a second. All right. I'll have to try and do that going forward, but thank you. Can I get my exhibits back, Judge?
Yes, sir.
Have a good day, everybody.
Thank you, too.
Have a good one. Sure.
Happy birthday to Detective Rachel.
Yes,
This is more medical exam?
yes. You know, he called my office about a half hour after we had adjourned at 9 o'clock. And he says, "Oh, I can make it now." Let me just make sure everybody else can work these.
I can't believe it. Graduate school. What is the time?
I don't know. She's lucky I. Because she sends me a text message. Listen, she's a pretty responsible. She sends me a text message at the end of the day. She goes, "Oh, I need to tell you this, but my tuition is due today." And it's like, it's a huge number. And I said, when is it that you thought you should tell me that your tuition is due? They just told you now tuition is due in 20 minutes. So I looked back on her, I mean, there was at least the option for payment plan, like we pay $1,000. I said, show me, I haven't even seen the bill. She sends me the bill showing that she was billed in June, July, August, and she could have gotten a payment plan and was livid. And on top of that, that she texted.
I text you too.
Yeah, right. She probably knew. I said, don't you ever text me, asking me for money again. You need something, you call me. Your emergency is not, I was talking to a friend of mine and he said, God, he said, back in the day, what would your mother have said to you? My mother would have said, figure it out. It's like. Right. Wow, that's right. She goes, well, you know, the university server was down all week. I said, yeah, this week. It wasn't down all summer.
Well, at least she's finished and continue. My youngest gets to this third year. and Decides college isn't for him anymore. Drops out
After his third year?
after this third year.
The years worth of tuition.
Yeah.
I'd make this, and how can you? Well, my oldest dropped out. She's 80. Are we on?
I can't hear. Can you hear me?
News.
Okay,
Okay, there I go.
thank
Are you
you.
ready on this question?
I'm ready for the case to be called, yes.
Okay. Calling case 2260108, people of the state of Michigan versus Catherine Lynn Bester. Defendant is charged with count 1 assault with intent to murder, count 2 assault with intent to do great bodily harm, less than murder by strangulation, count 3 assault with a dangerous weapon, count 4 domestic violence. Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Rebecca Chiappo, P 62311, on behalf of Ms. Bester, who is present in the courtroom, ready to proceed.
Today is the date and time set for preliminary examination. Are people ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Ayana Jasper. Your Honor, our office has not been able to locate her. The officer in charge of this case has tried for a time now to try to locate this complainant. We have been unable to do so, Your Honor, and I can't proceed at this time, and I don't have any specific information in order to ask for an adjournment at this time.
Your Honor, respectfully, I would ask for dismissal of this matter.
So ordered. Court will dismiss this matter without prejudice. Let me say this to you, Ms. Bester. The case has been dismissed. I want you to stay out of trouble, though, okay? I don't want to see you anymore. Not under these conditions, all right? Try to be on your best behavior. If you need some help, seek that help, okay? It's okay. It's all over now, all right?
Thank you, Judge.
All right, thank you.
Thank you, Judge.
I get the paperwork down there, so.
Okay. Yeah, you're all right. I was there. Appointed or retained? Appointed. I'm right on there. Missing something? I got the date of birth. It's 8/22/03.
The yellow one was TF. That one.
You got this, you got this.
Hey, how are you? Good. How are you? Good. What? Not yet. I just told the judge to call like half hour after we got everything adjourned. And I had already left. And he said, I can make it. Oh my God.
Come on, dude.
Oh, Dr. Son. Judge.
Yes.
Talking about kids again, my oldest is in my office working today. Yeah, so she just sent me a text message, says, can you send me the code I just sent? So I thought it was like a code for Discovery or something. Netflix code. So I thought you were working. Yeah,
Netflix fast the time.
yeah,
Everybody on here.
yeah, but we need him and his son on the son here. He's gonna zoom in, so. Yeah.
This needs to be on one of those cards.
This case?
Interesting.
Yes,
Interesting.
it is. It's the first more interesting one I've gotten in a long time. No, really, you don't think it's interesting?
Very interesting. Amazing TV.
My investigator loves it too.
You guys put me on the hot seat.
What?
You guys put me on the hot seat.
Oh, sorry.
Yeah.
File away. Here we are. Okay.
Suited to be on the exam. Yeah, I mean, I can write down all the names for you. Yeah, no problem, yeah.
Hey, how you doing?
Good, how are you?
All right.
You got time for me to set your stuff up? Yeah, you know, that's one change.
How you doing today, girl? I'm good. How about yourself? I'm doing fine, thank you. Just have a seat.
Tommy's here in person. I thought you were zooming, Dr. Sun. Well, here you are. Excellent. We're so happy to see you. As always. What?
Where would you like?
I just have to see till we're ready.
Give me about 5.
Are you feeling better?
Better. It's not just.
Yeah, you had COVID, right?
Yeah.
The last, not this time, the time before that. Did you have very many symptoms from it?
It's just fever.
Yeah. When I have it, I was mostly just sore throat. Like the first one. Oh, really? Did they get it too?
Yeah.
Yeah. You don't care all the time, right? Karen has had it sometimes. Yeah. I think the last time, the first time she got it since. Oh, 2020. She could do a whole document. Yeah. She's a good judge. Why don't Michael back? Oh, she just had a baby.
Yes.
Oh, that's.
And
Yeah, right. Oh, that's. Yeah. Oh, that's. I saw her one time when I was on my phone. My son, where I walk in the room, it's her. I really. Yes. Yes. Just on the. He's no expert. I don't even like stipulations. How many doctors do you have over there? 5. What is that?
20.
28. Any plans for the weekend? Trial project, 3 trials in a row starting Tuesday. So, I wonder the guy that's supposed to start Wednesday. That's what we can do today. He's on multiple CFC. That's what we got to. Okay, so we got it back. I think of it as just think of it. It's 3 of them. We try all together. 3. It just like. So. But. And so Steve, the rest is our. You guys. Take it. He's like. That's the one I know. I love to do. That's a great place to try to keep. My 3 cases are there. There's a bench on with Tuesday.
Karen McClinton.
Yes.
You actually a little ahead of schedule.
No, it's not good.
Calling case 2-57930, state of Michigan versus Karen, Mrs. Clinton. Defendant was charged in count 1 homicide, murder, first degree premeditated. Count 2 weapons, firearms, discharge, entering the building, causing death. Count 3 felony firearm, count 4 felony firearm. Appearances for the record.
Good morning, Your Honor. Brendan Sawyer for the people, PH3033.
And good morning, Your Honor. Gabby Silver, appearing on behalf of Aaron McClinton, who is present in the courtroom behind me to my left.
Tell me your name, sir.
Aaron McClinton.
This matter was held in part on August 28th and continued to today's date. Are we ready to proceed?
We are, Judge.
Yes, Your Honor.
Ms. Silver, you calling witness?
Yes, Judge, I'm calling one witness, time.
So please step forward, give your name and spelling of your name to the court reporter. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat with the witness box next to me. Maybe getting you ready.
Thank you, Judge. Sir, can you state your name for the court record?
My name is Lockman Son.
And is that Dr. Loughnan's son?
Yes,
And how are you employed, sir?
I am the interim chief medical examiner at the Wayne County Medical Examiner's Office.
Judge, I think there's a stipulation to Dr. Sun being allowed to testify as an expert in the field of forensic pathology. And what else? What other expertise?
Anatomic pathology.
Anatomic pathology.
So stipulated, Your Honor.
All right, the court will make a finding that this witness may testify as an expert in forensic pathology and anatomic pathology.
And in fact, we've already stipulated to the entry of the medical examiner's report, which is on Exhibit 1, equals Exhibit 1. Dr. Sun, I want to draw your attention to an autopsy that you did on April 8th, 2023 on medical examiner file number 2304497. Did you in fact conduct that autopsy?
Yes,
And that was of an individual for the record named DeAndre Fortson. Is that correct?
yes.
Now, we've already stipulated to a report being entered into evidence as an exhibit, but I had some questions for you related to the time of death of Mr. Fortson. Are you able to tell us to any degree of certainty as to when Mr. Fortson may have died?
No.
And why is that?
There are many variables that can determine time of death. Many of those variables are not typically accounted for in published formulas for calculating time of death.
So when you say you're not able to tell us time of death, are you able to give us an estimate in terms of days, perhaps, after viewing the body, that body may have in fact been dead?
It depends on the condition of the body, but in general, no.
Okay, so in looking at this particular medical examiner case file, are you able to tell us if this particular individual had been dead for 7 days?
The status of the body is not consistent with being dead for 7 days, with the exception of preservation of the body.
Okay. And can you explain for the record what that means?
If a body is preserved, such as in refrigeration and or freezing, it will stop the changes of decomposition in that body. Or slow down.
Was there any evidence that this body had been preserved in any way?
No.
Was there any evidence that this body had been frozen in any way?
No.
Are you able to tell us, you said that you can say that the body, the person had not been dead for 7 days. I think when you and I had a telephone conversation about this particular case, you had indicated that the body could not have been deceased for longer than 24 days, 24 hours. Does that sound accurate?
Yes,
And why do you say that?
the body did not display extensive signs of decomposition, and if it did, that would generally indicate a longer period of interval on being dead.
Are you able to tell us if this individual had been shot on April 1st, could they have lived for 6 days before dying with no medical treatment, no care, no water, no food, nothing?
No.
I don't have any other questions. Thank you.
Cross-examine.
Dr. Sook, you testified about preservation of the body, correct?
Yes.
All right. You have a method for preserving bodies at the medical examiner's office?
Yes.
And what is that?
We have refrigeration units and also freezers for preservation.
And how cold are the refrigeration?
Approximately 0 centigrade.
And how cold, 0 centigrade, so that would be roughly 32 Fahrenheit?
Yes.
And do you know, well, you testified there are no published formulas, correct?
There are published formulas, however, those formulas don't take into account many factors such as clothing, environmental temperature, surfaces in which people are found.
And so if a body was outside, would it decompose faster or quicker than if it was inside?
It depends on the temperature difference between the outside ambient temperature and the inside temperature.
And in your report on page 2, which was admitted as People's Exhibit 1, under the sort of narrative summary, you have a date of pronounced death of April 7th, 2023. Can you explain what that date means?
That date simply means the date in which the decedent was discovered and pronounced dead by representatives of either law enforcement and or the medical community.
And no further questions, Your Honor.
Can you read it right?
No questions, Judge.
Sir, was there any bullet fragments or part of the bullet that was recovered from the body?
Yes.
And when did you do that?
The bullet was clean, photographed, and placed into an envelope and placed under chain of custody in our locked vault, and the bullet has been available for police.
Any questions based on my question?
No, Your Honor.
No, Your Honor.
Thank you, sir. You used some pretty time. Any other witnesses for the defense?
No, Your Honor.
No further witnesses, Your Honor. At this time, I'd make a motion to bind over on all 4 counts there as charged. Certainly, the court heard the testimony of Ms. Boykin several weeks ago regarding being at the Hartwell address of 20152 on April 1st, on being there with Mr. McClinton, essentially sort of inviting him there to the, I believe her word was the muscle, to get Mr. Fortson out of her house. We certainly heard testimony about the situation that Ms. Boykin was going through regarding Mr. Fortson sort of occupying her house against her will at that point. And she testified regarding inviting Mr. McClinton over. And then we also heard Mr. McClinton's own statement, read by Sergeant Reed, who testified last time, and that was also admitted as People's Exhibit 3, regarding what happened in the discharge of the firearm at the Hartwell location at that side door of the house on April 1st. Sort of while this tussle was going on over the door there. Now, As to, I suppose, really the biggest question would be, is it murder in the first degree? And to that, I would just offer that Ms. Boykin testified she invited over Mr. McClinton. Every block that Mr. McClinton drove to that location with that firearm was an opportunity to weigh the pros and cons, to consider the consequences of what was going to happen there. And I believe for that reason that murder won't be appropriate. Certainly the placement of the body in relation to the testimony of Ms. Boykin and Mr. McClinton's own statement, it's right there at the side door. Now, we certainly heard from Ms. Dr. Sung today about there's a lot of things that might go into decomposition. Ultimately, a lot of them are sort of beyond his area of expertise or beyond what his involvement in the investigation would be, what the ambient temperature was outside, what the ambient temperature would have been inside in that stairwell there in early April. And if he had said that there were no formulas related to measuring decomposition at a scientifically approved level, I believe it's an appropriate inference in light of all the direct and circumstantial evidence that on April 1st, the discharge of Mr. McClinton's gun ended in the death of Mr. Fortson. For that reason, I'd ask.
Let me ask you this.
Yeah.
So the doctor said that there was a bullet fragment or bullet that was from the deceased body. Is there any comparison none of that with the weapon that you can associate with?
There was. It is consistent with the caliber of a firearm later recovered in this investigation.
So, for purposes of this exam, no.
Not with the witnesses that have testified so far. But I believe it's a logical inference in light of the placement of a body related to where those shell casings were recovered. We certainly heard from Officer Goff. There's 2 shell casings right there. Ms. Boykin said she heard the shots right there. And important, I think, Mr. McClinton's own statements regarding what happened after those shots. After the shots, did you see the guy in the house? No. Right? That was it. That ended Mr. Fortson's struggle regarding that door after he was shot there. For that reason, I find it was appropriate. On first degree.
In your premeditation, just because you went over there with him. What about the fact that the witness testified that the deceased pretty much tried to sick the dog, fired a shot to the door? Doesn't that sound more like second degree?
I certainly would ask the court in the alternative to find it over on the second degree. But I've already sort of said all of what I have as it relates to first degree.
Yeah, I don't know how it gets found over at all. I mean, so Dr. Sung testified that while he can't say for certain what the time of death was or when death occurred, he can say a couple of things that I think are important to this case. Number one, that there's no way the body lay there from April 1st till April 7th and then died on April 7th. He said that's not possible. He also said that although he can't tell us the date and time of death, he can tell us that the body, what he visualized, what he saw, was that the body had not been dead for any longer than 24 hours. And that's based on what he saw when he viewed the body. So how that puts any window there for Mr. McClinton from April 1st, if you believe that Mr. McClinton shot into that house and hit this man. I mean, we heard testimony from the witnesses that there was no damage to the door. And not only that, so maybe he shoots inside the door when the door is open, but there's no damage, there's no bullet holes inside that door at all, inside the wall, inside the area where there certainly would have been had Mr. McClinton been firing into the home from where it is, it was said that that's where they were standing. So it seems that based on the testimony here, it's absolutely impossible for Mr. McClinton to have caused this man's death by firing the gun on April 1st. I mean, it was absolutely clear from the medical examiner. Yes, you're right. I can't tell you an exact date or time, but I can tell you that that body has not been dead for longer than 24 hours. So that puts us to April 6th. So that puts Mr. McClinton being at the house on April 1st. That's the day that the witness testified they went there. That's the day Mr. McClinton said he went there. So for those reasons, I don't, it's clear to me anyway, and I think it should be clear that whatever happened to this man did not happen on April 1st.
Let's see, on top sheet.
Would you like to see the photo of the body as well?
Sure.
I'll tell you something else that was interesting to me, is that there are dogs, vicious pit bulls, according to the witness. And those dogs, if we believe that Mr. McClinton, that this happened on April 1st, we've got this body laying there from April 1st until April 7th with these vicious dogs. There's food out in the house, according to one of the police officers. That food hasn't been eaten by these dogs. There's no attack on this dead body by the dogs. And these are large, vicious dogs, according to her, baby and a mom.
They were trying to keep their master.
Well, maybe not, Judge, but the master's dead now. They're not eating the food that's in the house.
That's more persuasive.
Yeah, I mean, we heard from the police officer that there was food. There was food out.
And I handed the court, I believe, defense counsel requested, what was admitted was Gibbs Exhibit 5, the photograph of him there. And I think there's something that was important in the photograph that was admitted that's actually corroborated by Mr. McClinton's statement that was read into evidence, where he was asked on page 3, can you describe the man inside the house? Tall, light skinned, belly, hairy, in his underwear, right? Sort of an accurate reflection of exactly how he's found on the 7th of June. Now, sure, maybe there is a reasonable doubt, but by the standard of probable cause, he's dressed exactly the same as he was when Mr. McClinton saw him on the 1st, when he was found there dead with the gunshot in his torso there on the side. For that reason, I believe find over is appropriate.
So if this court was to bind over at all, I definitely would not bind over on first degree murder premeditated based on the testimony that I've heard. I think anything had a second degree murder, a weapons firearm discharge into the building causing death, which the felony firearms that would come to the same. The reason I asked to look at the autopsy report is I wanted to know there was rigor mortis. And the autopsy report says the body was cool, rigor mortis was fully developed. But I don't know how long it takes for rigor mortis to fully develop. Could be within the 24 hours. But I do take note that Dr. Sun, Dr. Sun indicated that based on his expertise, that body could not have been dead for more than 24 hours. If that is in fact the case, then this defendant, Mr. McClinton, could not have killed him on April 1st. The body was recovered on April 6th, April 7th, on April 7th, some 6 days later. I would think that the medical examiner with this kind of experience would be able to tell us approximately how long the body has been dead, but versus 1 day versus 6 days. I would think he would be able to tell us that with some certainty. This body was not outside, it was indoors. There's just a lot of things that don't necessarily add up. One of which is the dogs that were located at this residence. I would think that if the dogs had been left unattended to for 6 days, not fed, they would most certainly find a way to find to that food to the house. They probably would have attacked police officers if they came in. But none of that happened. It's a mystery to me if the defendant shot these 2 shots. Where did those 2 shots go? The reason I asked the question, was there a bullet fragment recovered from the complaining witness? Was there some kind of comparison made between that bullet and whatever gun that was recovered that they can associate to the defendant? None of that was part of this hearing. But it would give me some insight as to whether or not this was the weapon that was used. Quite frankly, we don't have that information available. So I'm told that there were at least 2 shots that were fired. We know 1 shot took effect. What happened to the other shot? I don't know. Is it possible that someone on another date came to that same side door and the complaining witness, Mr. Fortson, opened that same side door, still wearing underwear? I don't know if it's the same underwear. It could be the same color underwear. We buy underwear in packs, and a lot of times they're the same colors. Same colors blue, same colors black, or varying colors blue, black, or gray, or white, whatever the case may be. Or did he just not change his underwear? I don't know. I don't know if they would go there. But honestly, I don't think you have proof beyond a reasonable doubt here at this stage, which people aren't able to find. But don't have to show here, you just have to show probable cause. What do I have? Probable cause. I'm certainly not a person who never committed it. But based on all the evidence that I have here, it's not scientifically possible based on the medical examiner, Mr. Song's testimony, that the defendant could have caused this murder on April 1st, based on the evidence that I have here. As such, the court is not satisfied with the burden of probable cause. Dismiss this matter for insufficient evidence.
Thank you, Judge.
Thank you, Your Honor.
Give you back your exhibits.
Yes, Judge.
Okay, so,
May I approach?
Yes. So we are on lunch until 1:30.
The next one.
Next.
Yeah, I don't even. I don't see what I-
No,
I mean. The generally consistent. I'm sure, but doesn't fit that issue.
no.
Well,
I, you know. To one of them, I had, and a dog. Circling around. They got water bowls.
No, not a dog expert.
Okay, they would have for sure drank all the water by then. Forgot about that part. There's water in the dog bowls. Yeah, like the dogs would have for sure drank that clean by then. I think so too. The neighbors, that's what I've been trying to get my investigator go out there over and over again. Because one of the neighbors said that somebody had been bringing food to the house for him after the first. And remember there was the hearsay that I was getting in that you were jumping all over me about? That officer said that two other officers had been there that week after the first for another call about some games that had been stolen. And I can't find those, I can't find the reports, so I'm trying to, I don't know. Yeah. Didn't sound like you have very many friends in the neighborhood of that gentleman, anyway.
We will commandeer somebody's house.
Right. Stick your dogs on people.
Yes, sir. Can I help you?
Yes, can you hear me?
Yes, sir. What can I do for you?
Sorry about that before. My daughter is a witness in today's proceedings.
Okay, you have to view these matters on YouTube or come down in person and view it.
Okay, thank you.
All right, thank you. Have a good day. Is here? Okay. Yeah, I think I've waited long enough.
Judge, I apologize. Just got on my hearing.
Monte Brown. Calling case 2358391, people of the state of Michigan versus Lamonte Dewan Bryant. Defendant is charged with count 1, homicide, murder, first degree premeditated. Count 2, felony firearm. Appearances for the record, please.
Thank you, Judge. Eric Moses on behalf of the people, P 78491.
Good morning, afternoon, Kathy Sharif, 71454, Mr. Monte Brown, who's present, standing next to counsel.
Tell me your name for the record, sir.
Monte Brown.
There's been time set for preliminary examination. Are we ready to proceed?
The people are ready to proceed, Judge.
How many witnesses will it be?
Approximately 3, Judge.
Do you have any preliminary matters you'd like to deal with for your call witnesses?
Judge, I guess some mutual sequestration. I know some family members, Mr. Christopher Johnson are present. I don't believe any of them will be witnesses in my case. But they would like to observe.
Do you have an OIC?
I do have my OIC, Detective Pye present.
Any objection to the OIC remain?
No objection to the OIC, Judge, I just want to make sure none of these people are testifying.
All right, ladies and gentlemen in the audience, if you are a witness or potential witness, I'm going to ask that you excuse yourself and step into the hallway to further notice. If you remain knowing that you are a witness, make sure you're testifying at a later date. Also, people out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time.
Your Honor, I'm logging on to your Zoom. I do have videos that I may present.
Sure. And then you also say, ladies and gentlemen in the audience, I don't know who is who, but who belongs to who. All I know and all I care about is that there be no disturbances during this hearing. If for whatever reason, and I know these things can be emotional, but for whatever reason, if you can't control yourself, I'm asking you to step into the hallway, okay? Because I want you to go out that door and not this door. There are any disturbances, and I don't care on what side you fall on, if there are any disturbances, I'm going to deal with it immediately. So long as we have that understanding, I shouldn't even know that you guys are in the courtroom, okay? Ms. Moses, when you're ready?
Yes, people are ready, Judge. May I call my first witness?
Yes.
The people call Miss Carlotta Hamilton.
Now, please step forward, give your name and spell to the young lady sitting over there waving at you. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat. The witness box right next to me, right up here. Open up the door, have a seat. Speak nice and loud into that microphone that's going to be to your left, okay? You may begin when you're ready.
Thank you, Judge. I may have a moment while actually.
You can hold that in your lap. Just take the whole face, put it in your lap, and speak directly to that.
Good afternoon, Ms. Hamilton. Can you please state your name one more time for the record?
Carlotta
And what's your last name?
Hamilton.
Ms. Hamilton, are you familiar with someone named Christopher Johnson?
Yes,
How are you familiar with him?
My fiance,
Okay, and how long have you all been together?
9 years,
Do you have any children together?
2,
Okay, how old?
10 and 7
And boy, girl?
boys.
Now, I want to direct your attention to July 10th of 2023, okay? I want you to look at me. Focus on me. Do you remember that day?
Yes,
Okay. On or about that day, did you have reason to go to that 3026 Tuxedo Street in the city of Detroit, County of Wayne?
yes,
Okay, why did you go there?
I was called
By who?
Zane.
Okay. And what information did you have?
They said that he was shot.
They specified who they?
No, they just said he was shot and to get there quick.
Okay, who's he?
Chris,
And how far away do you live from that 3026 Tuxedo Street?
3 blocks.
What did you do upon getting that call?
I got up and I ran out the door.
Did you get into a vehicle?
Yeah, somebody seen me coming down the street.
Okay, and do you know if Chris had been in a vehicle that you own or had been at your property before?
Yes,
Okay, and what kind of car do you typically drive?
Nissan Road,
And what color?
white.
And what time of day did you go to that address?
It had to be at 1 something in the morning.
When you got there, what's the first thing you saw?
I seen everybody running out the house.
Okay, are you familiar with that location?
Yeah,
How were you familiar with that location?
they friends.
Okay, who's they?
Tip and Zane.
Okay. And Chris, they're all friends together?
Yeah, we're all friends.
So when you got to that address, what did you see?
I seen everybody run out. I said, where was Chris? They say he in a car and he was shot.
Okay, did you see this white road that you own?
Yes,
Where was it at?
in the driveway.
Okay, and what were your observations of the car? Did you see it at first, make any observations of it?
It looked normal and then I looked and I seen that it was shot.
Okay, when you say it was shot, how did you know it was shot?
Cause he was in the driver's side and I seen the bullet hole.
Okay, who's he?
Chris,
Was anybody else in the vehicle with him at that time?
No.
You could see. Did you make any other observations of him?
no,
Okay. Did he talk to you, Chris?
no,
Did he appear to be breathing?
no,
Could you see any blood anywhere?
it was everywhere.
When you say everywhere, I know this is difficult. You should tell me where you saw it.
On the steering wheel, on the seats, on the seatbelt, just everywhere in the car.
And how long were you at that location for?
Like, I was on the phone with EMS and then we moved his body to the passenger side. I drove him.
Okay, when you say we moved his body, who are you talking about?
Me and my neighbor who had brought me over there.
So you get there, are you saying you transported in the same vehicle that he was in, that Nissan Road?
Yes,
Okay, and how did you move him to the passenger side?
with the help of the neighbor.
And did you physically move him or was Chris able to move on his own?
You know, me and Booby had to move him.
Just from the outside appearance, not looking at clothing or anything underneath clothing, could you see any type of injury on his?
Just his neck,
What did you see on his neck?
just blood, lots of it.
When you got to the hospital, did they come and take him in and you go somewhere else or did you stay at that hospital?
I stayed there.
Now, when Chris, did you know beforehand that Chris was gonna go to that address that night? Or did you have any inclination he would be going?
Yeah,
Okay. Do you know if anybody had gone with him?
just my son,
And your son's how old?
7,
And where was he in that vehicle? Where would he typically sit in?
in the backseat.
When you got there at about 1 something AM, correct?
Yeah,
Did you see your son anywhere in that vehicle?
no,
And you subsequently went to the hospital, correct? Okay. Did you talk to Chris at all?
yeah.
Okay. When
I
you
was
say,
trying to get him to like wake up. I was like hitting his leg, like, baby, please just stay with me. And just trying to drive him to the hospital.
how long was that trip from that house to the hospital?
Like about 10, 15 minutes.
Did Chris make any kind of movements in the car during that 10 minutes?
No.
Could you tell if he was breathing in the car during that 10 minutes?
No, it wasn't.
And then when you got to the hospital, what happened?
They came out. Not until they came, they got him out of the car.
Did you see Christopher alive anytime after that?
No,
Another question.
Question, yeah.
You didn't drive to that address on Tuxedo with Chrissy.
I'm sorry.
You weren't in the car when Chris drove to that address on Tuxedo, were you?
No,
You did not witness any incident that took place that day.
no,
You didn't witness a shooting.
no.
Have nothing further.
You redirect?
No, Judge, thank you.
Thank you. You may sit.
Your Honor, the people called Detective Stephen Hyde.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do, sir. Thank you, sir. Please have a seat. Thank you. When you're ready.
Good afternoon. Is it Detective?
Sergeant.
Sergeant, I'm sorry. Sergeant, can you say your name one more time for the record, please?
Sergeant Stephen Hyde,
And Sergeant, where are you currently employed?
the Detroit Police Department.
In what position?
I currently work for the homicide section,
And how long have you been in that homicide section for?
for a little bit under a year.
Now, I want to direct your attention to July 10th of 2023. Do you remember that date?
I do.
Okay, on or about that date, did you become aware of a situation involving a Christopher Johnson?
I was, yes.
Okay, how did you become aware of this?
I was recalled for a homicide scene at 3026 Tuxedo.
At some point, did you get confirmation that there was a deceased person by the name of Christopher Johnson?
Yes,
And did you conduct an investigation after that?
I did.
Okay, and as part of that investigation, did you get information about a suspect named Lamonte Bronner?
I did.
And at some point, did you have a conversation with Mr. Bronner?
I did.
Where did that take place?
At Detroit Public Safety Headquarters, 5th floor.
Okay, is this in a private room or public setting?
It's in a private interrogation.
Okay, who was in that interrogation room at that time?
It was me and one of my partners, Lieutenant Matthew Bright.
And did you ultimately speak to Mr. Bronner?
Yes, I did.
Prior to speaking with him, is there anything you do procedurally?
Yes,
Okay, what is that?
our constitutional rights are read when somebody is in custody, in our custody.
Okay, and how are they read? Is it just verbal or is it something else?
So it's both verbal and then we have a constitutional rights form that is filled out.
Okay, and what do you do with that form? Who fills it out?
So somebody that's inside the room will read the constitutional rights form to the defendant. And at that point, we will make sure that they acknowledge that they understand their rights. And then they will then initial next to each one of their rights and then sign the form.
Okay, was there an indication by you that Mr. Bronner knew those rights, understood those rights?
Yes, he did acknowledge that he understood his rights.
How did he acknowledge?
Mr. Bronner was read his constitutional rights by my partner, Lieutenant Bray, and then he then initialed next to each one of his rights and signed the constitutional rights form.
May I approach, Judge?
You may, but it looks like you may have a corpus electi problem right now. You haven't put it in bed for the time.
Judge, may we approach?
May proceed.
Thank you, Judge. May I approach this witness?
Ma'am.
Sergeant, I'm showing you what's been marked as People's Proposed Exhibit 1. Do you recognize what that is?
I do.
And what is that?
It's a constitutional rights certificate of notification.
Okay. And is that the same form that you showed to Mr. Bronner?
It was the form that was shown to Mr. Bonner, yes.
Is that a fair and accurate representation of what you showed him and what he signed?
That is correct.
And what's the date on that signature?
In August 10th of 2023,
Is there a time on there?
4:12 p.m.
Okay, now is Mr. Bronner's signature the only signature on there?
No, there's not.
Whose signature is also on there?
Lieutenant Matthew Grace.
And are there other notations on that document or no?
Yes, there is.
What's on it?
Mr. Bronner's name and his date of birth are at the top of this form.
Judge, I ask for admission of People's Proposed Exhibit 1.
Conditionally under,
Yes, Judge. Yes, Judge.
taking it under advisement based on our sidebar conversation.
Following the signature on that form, I'd ask for publication. Following the signing of that form, did you have a conversation with Mr. Bronner?
Yes, I did.
Did Mr. Bronner at some point talk about this case?
Yes, he did.
Okay, and when he spoke about this case, what exactly did he say happened? With
Mr.
regards to Mr. Johnson?
In regards to Mr. Johnson,
Yes.
Mr. Bronner had stated that he went to the location of 3026 Tuxedo. He said he knocked on the door and a female answered. He had asked where his truck was and where Tip was. At that time, Mr. Bronner stated that he had retrieved a rifle from inside of the home. Then had took the phone from Mr. Johnson that was parked in the driveway of the location. At some point, Mr. Bronner's gun went off, striking Mr. Johnson, and he fled the scene.
During the course of your conversation with Mr. Bronner, are you just having a back and forth conversation or is anything presented?
There's several things that are presented,
And what's presented?
photos and a video.
Let's talk about this video. What video are you talking about?
This was a video I received from Monique Williams. It was a screen recording of what we believe to be the cameras recording at the location of 3026 Tuxedo.
Prior to presenting this video to Mr. Bronner, which you did, correct?
That is correct.
Did you ask him questions about it?
Yes.
Okay, what questions did you ask?
So me personally, I was me and my partner both asking him questions. But it was identified, Mr. Bronner identified himself in the video.
Okay, so let me ask you this. Do you play that video?
Yes.
To Mr. Bronner?
Yes.
What are you playing it on?
On my laptop.
Okay, where is it in comparison to Mr. Bronner?
It's in front of him and my partner, Lieutenant Bray, is next to him.
Okay, did you have an indication from Mr. Bronner that he could see that screen?
Yes.
Okay, and did you play that full video for him?
Yes.
You know approximately how long that video was?
I do not. I think it's 2.5 minutes, maybe a little bit longer.
And in regards to the video, you indicated Mr. Bronner made some statements, correct?
That's correct.
What exactly did he say either before, during, or after watching that video?
Mr. Bronner identified himself as the one going up the steps and knocking on the door. Mr. Bronner also identified himself as returning. In the video, Mr. Bronner is shown walking to a vehicle and then returning. Mr. Bronner made the statement, "Yes, that's my line."
Sorry, this is
My limp. Limp.
Judge, I seek to amend People's Proposed Exhibit 2, which is this video that Sergeant discussed.
Any objection?
No, you're right, she wanted to play video.
Yes, it's for everyone.
Any video?
Thank you. May I share my screen? Now, before I share my screen, Sergeant, can you clarify something for me? What is this a video of? Is it a single video or is it something else?
It appears to be a screen recording of multiple camera angles from the location.
Okay, but you indicated that you showed this complete video, to me, correct?
That's correct.
Judge Maxwell?
Yes. Video code.
Sergeant, do you recognize this video?
I do.
Play it?
Yes.
Is this the same video that you showed Mr. Ron?
That's correct.
And Judge, for the record, this video is 4 minutes, 18 seconds long, so I'll stop it when you tell it. Is my sound turned up as well? Sergeant, what screen should we be looking at right now? Which picture?
The one behind it, because this is a FaceTime recording, the black box in the lower left, I believe, is the individual that's FaceTime with whoever received this video.
Now, there's a vehicle that just pulled up, correct?
That is correct.
Okay, did Mr. Bronner identify that vehicle at all? As who owned it? Who's driving it?
No, we did not.
This individual that just came in the frame. Did Mr. Bronner identify who this individual was?
Yes, he did.
Who did he say it was?
He identified him as himself.
Now, Mr. Bronner steps out screen. Did he say where he went to at that time?
He didn't personally tell me.
Okay. And at any point in time, did he identify anybody in that vehicle? Somebody he knew?
I don't believe so.
Okay. Now, at this time, there's something, there appears to be something in Mr. Bronner's hands. Did he acknowledge that he had something in his hands at that time?
Not at the time of him coming back from the vehicle. Mr. Bonner indicated to me that he had retrieved the rifle from inside the residence.
But he identified what he had as a rifle.
That is correct, yes.
Now, it appears Mr. Bronner has something else in his hand now. Do you remember him identifying what that was?
Yes.
What?
It was his cell phone.
Okay, did he say whose cell phone it was?
He said it was the driver's.
Something to do in there, Judge, at 2 minutes, 46 seconds. Did Mr. Bronner say anything else about this particular case about why it was found?
Yes, he did.
What did he say?
He stated that the reason why it went down was because he was very upset about being shot and robbed a week prior.
I know very much.
Cross-examine.
Mr. Bronner indicated that he was shot a week prior, correct?
That's correct.
He also told you that during that interrogation, he was under the influence of Norcos and Tramadol, correct?
No, he did not.
Did you ask him?
No, he said he was taking ibuprofen.
My question was, did you ask him if he was under the influence of any medication that was moved on?
I personally did not ask him.
Okay. You also didn't ask him, knowing that he was shot, was he under the influence of any prescribed medication that affects his cognitive abilities to think and comprehend, correct?
I personally did not ask him.
Okay. And in where it says, subject said he wasn't under the influence of alcohol, it has nothing about prescription drugs, correct?
I would have to review the sheet again.
Okay.
It states that he was not under the influence of alcohol or drugs.
Prescription drugs. It doesn't say prescription.
It just says drugs.
Okay, he did not write that, did he?
No, he did not.
Someone else wrote it, didn't he?
That's correct.
And he indicated that he couldn't clearly read and write, correct?
That's correct.
But someone else wrote that at the bottom of his statement, correct?
That's correct.
Okay. Now, you say Mr. Bronner told you that he was upset about being shot, right?
That's correct.
He never told you he killed Chris, did
I'm sorry, say that again?
he? Mr. Bronner never told you he killed Chris, did he?
He said he was sorry for taking his life.
Whose life?
He didn't identify Chris as the individual inside the driver's seat.
Okay, so he just randomly said, I'm sorry for taking his life. That's your testimony?
He stated in the interrogation that he was sorry for taking somebody's life.
Didn't you in fact tell him that if he confessed to just a shooting, that he would be let go home?
I never said that.
You never put the words in his mouth and told him what to say?
I did not say that.
Your testimony today, you never said that.
That is correct.
Okay. The interrogation was taken, correct?
That is correct.
And again, I'm gonna ask the question, because I just want to make sure of the answer. Mr. Bronner never said he shot Chris.
He never specifically stated Chris, no, he did not.
Okay, thank you. Mr. Bronner appeared to be very shaken up, correct?
I'm sorry, say it again?
He appeared to be very shaken up, correct?
I don't know what you mean by that.
Did he appear to be anxious?
Not, no.
Did he tell you he was in pain?
He did tell me that.
And when he told you he was in pain, he told you that he wanted to leave, he said he wanted to get the pain checked out, right?
No, he did not.
And you didn't ask him about prescription medication?
Me personally, I didn't.
Did you do the interview me personally?
It was me and my partner, Lieutenant Brian.
Okay, but you didn't ask him.
I did not ask him.
You didn't hear your partner ask him, you did.
I believe my partner asked him if he was under the influence of alcohol or drugs, and he said no.
My question
Other than
was,
undergrowth.
when he was telling you he was in pain and that he was shot, your partner, you didn't hear him either ask him about prescription medication.
I didn't, specifically prescription, no, I did not hear him say that.
So you don't know what cognitive state Mr. Brown was in at that time.
I'm sorry, say it again?
You don't know what cognitive state Mr. Brown was in.
His cognitive state?
Yes.
No, he appeared to be normal.
You don't know what his baseline is, do you?
No, I did not.
Thank you.
Your Honor, the people moved to admit proposed exhibit 2, I don't believe I did that previously. This is that video that was just played for you.
What you did, there was no objection. Thank you, sir. Ms. Smith.
Thank you, Your Honor.
Your Honor, the people call Detective Carlisi. That's Antonio Carlisi, Your Honor.
Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. And you're ready.
Let me have this one. Good afternoon.
Afternoon.
Detective, where are you currently employed?
City of Detroit Police Department.
I'm so sorry. Restate your name one more time for the record, please.
Detective Antonio Carlisi,
Detective, where are you currently employed?
City of Detroit Police Department.
What position?
Homicide.
Okay. And what do you do in your position?
So my sole job now is to recover and extract video evidence.
And on or about July 10th of 2023, were you in the area or were you sent to the area of 3026 Tuxedo, City of Detroit, Pennsylvania?
July 10th?
Is it July, I'm sorry. I don't know what I said, July 10th, 2023.
No, July 13th.
Okay, so July 13th, 2023, you go to do what at that location?
At 3005 Tuxedo, I was requested to extract video from that location.
Okay, and what kind of video are we talking about?
Surveillance video.
Okay, is it a business, home, or something else?
It's a residence.
Okay, and how do you go about extracting the video to?
So with that system, which was a Honey Vision DVR, which is a DVR box, basically you just go into the system, search for your date and time, what you're looking for, and for what camera, and you export it through the DVR onto what I have is a formatted thumb drive.
I'm sorry.
I exported the video from the DVR to my formatted thumb drive.
Okay, and what did you do with that thumb drive?
And that then goes to my workstation where I process the video and place it on evidence.
And in this particular case, did you find video pertaining to July 10th of 2023?
Correct.
Okay, and was there any video in the later hours after midnight of that day?
I recovered one camera, 6 from midnight to 2 a.m.
Did you review that video?
I reviewed something, yes,
Okay,
ma'am.
is there audio to that video?
That I don't recall.
Is there a view of 3026 Tuxedo from that video?
Yes,
And did you subsequently give that video to officer in charge?
yes.
The people seek to admit, people propose exhibit 3, which is surveillance video, timestamp, I'm sorry, 2013.
Any objection?
Okay.
Admitted.
Judge, just for the record, this is, an entire length is 1 hour, 19 seconds. This video does have audio, Judge, so.
You're playing the whole hour?
No, sir, just a few minutes.
Okay.
I'm starting at 2013.
Okay.
Judge. First, we're make sure the screen, sorry.
I don't hear anything. You share audio as well?
Okay, Judge. You may not hear anything right away, there's not dialogue, so. Stopping that video at 22 minutes, 50 seconds. I'm not going to proceed to admit, people's before exhibit 3, that is this video, I don't have questions.
Yes, sir. No good questions begin. Thank you. You just testified that you extracted a video on July 15th, correct?
July 13th, yes.
That's 3 days after the shooting, correct?
Correct.
You do not know with any level of certainty if that video was edited prior to you getting it.
I couldn't tell you
You couldn't tell me if it was cropped prior to you getting it, did you?
if it was cropped.
Yeah, if it was edited in any form or fashion, you don't know that, do you?
No.
So your job is simply to take what was given to you.
No, I take it. So I go into the box itself and pull that video from the device, from the hard drive itself.
Got it. So what's your title?
Detective.
Okay. And detective, those prior 3 days in between, someone else could have went in and obstructed that video, did not know, correct?
No.
You just
No,
said-
because it's coming from the hard drive. You cannot edit or do anything from that device.
You're saying you can't edit it?
Not from the device, no.
How can you edit?
You would have to extract it from the device and use software to do editing.
You weren't in that house those 3 days prior, though, were you?
No.
And you don't know if that happened, do you?
That someone took, I didn't take it from anything but that device, the hard drive.
That is correct. If you don't know, someone else of your same skill, not from your department, of your same skill came in and did anything to that device and or hardware, did you?
Did anybody come in? I don't understand your question.
You just testified that you came in and you extracted data from the device, correct?
Correct.
Those 3 days prior to you coming in, the shooting was on the 10th, right?
Correct.
You looked at the device on the 13th, correct?
Yes.
You don't know if another professional came in and extracted anything from that device. do you?
Extracted, no, I do not know if anybody else extracted any video from that device.
Thank you.
Just may I ask a regular question?
Yes.
If someone had gone and extracted from that hard drive prior to you being there, would that have any impact on the information that you yourself are getting from that hard drive?
No.
So I can't just go take a hard drive out, mess with it, throw it back in, and have you extract it and do something there.
Correct.
No further questions. Just one.
When I previously asked you if you knew if it had been edited, you answered you did not know.
Correct.
During my first set of questions. So that would suggest that someone could have done something and you not know.
You asked if they gave me the video. They did not give me the video. I extracted it directly from the device. You cannot take video from the device and put video back onto the device.
How can you edit it?
Again, you would have to take the video off the device, use software. You cannot take that edited video and put it back onto the device.
But there is software available to help edit.
You would have to take the video off the device and use software, yes. There is editing software.
But your testimony is once that's done, you can't put it back into the device.
Correct.
Thank you, sir. You may stay.
Thank you.
Because if people recall OIC, just for one question. Guys, we vote? Is it necessary? No, it is necessary. I need. Can I begin, Judge? Sergeant, you said you spoke with someone by the name of Lamonte Bronner, is that correct?
I did, yes.
You see a Lamonte Bronner who identified himself as Lamonte Bronner in the courtroom today.
I do.
Can you please identify him by pointing and saying something he's wearing?
Yeah, he's in a Green Wayne County jail.
Judge, that's for your court identification.
So noted.
Lord, Dr. Kenneth.
So we just have the matter, you may start. You didn't have any questions. So we just have the matter of the autopsy report.
Correct.
And we hope to have that by next week, if not soon. Well, have to be next week, today's Friday.
Your Honor, Sergeant has just indicated that his office has been contacted the ME's office to see the status of the report. There's not been a response. I know Sergeant will go and continue to request it urgently. I do start the homicide trial on the 5th, next Tuesday.
I will tell you what normally lights a fire. I will tell them either they produce the report or they have to come in person to testify.
Understood, Judge. And there is a witness that I will subpoena as well. But my only issue, Judge, is that I won't be available the 5th, 6th, and 30th. I can do it the following week. though.
Your Honor, I leave for Cabo the 14th, so 11, 12, and 13.
How about 12?
Maybe in the afternoon, Judge.
So the 1:30? All right, this matter is held in part continues to September 12th at 1:30. Trial will be continued.
Judge, shall I keep the exhibits for now?
Yes.
Tramadol, let me do. This is Tramadol, probably the TR with him. I thought Tramadol was TRE, but I will. Here.
That concludes the document for today, folks. Hope to see you next Tuesday. That means don't get in trouble because the judge is out till Tuesday. Hope to see you next Tuesday, same bad station, same bad time. Week and out.